Hi, Bill Henshaw here again, your walking constitution on the San Francisco Peninsula. And more great news, it just keeps piling up here as we approach the Thanksgiving holiday. And that's my one holiday for the entire year, by the way, for me personally. I take a half a day. I have some fond memories of that growing up. But more astounding news about something you may never have heard of called the Rooker-Feldman Doctrine. This is how the bastards are doing it. And this is how we can hold them to account, start to assert our rights, and get them the hell out of our lives. This goes back to a case called Rooker v. Fidelity Insurance in 1923. And I was aware of it. I just hadn't seen it in the right perspective until recently. But you read this piece of crap. And this is embarrassing. It was at a time when the Four Horsemen were all on the court that objected in the 1930s, to the expansion of Commerce Clause powers. So they were on the court, and one of them wrote this case, Willis Vandevander, and an era in which they should have known better. I read it and I laughed. And the big deal is this, that the Supreme Court ruled, and if you know what you're reading, you can deal with it easily, that the federal courts did not have any subject matter over jurisdiction of claims like you and I would make after we go through the BS administrative tribunals. You've all been there: traffic court, family court, child procurement syndicate, IRS, you name it. Administrative BS. They ignore everything we do. They think we're not there. They think we're incompetent, among other things, especially if we appear as a pro se litigant. And they desperately want to appoint counsel. That's the only right they think you have, is the right to effective assistance of counsel, which in the grand scheme of their BS treasonous things means an attorney. And for those of you that don't know, all these attorneys are in on it. The State Bar Association attorney, British Accreditation Registry, unregistered foreign agents of at least the City of London, who probably don't even know most of the issues I advocate, and they sure as hell aren't going to bring them up in any of their courts. Not going to happen. Don't wait around for that. You'll be in the grave before that happens. So the big deal is that this Rooker-Feldman, and I laughed when I read the first paragraph, the basis for the invoking of this doctrine is that you appeared in a state, and they didn't say judicial, but in 1923 that may have been assumed, state judicial court that had jurisdiction over the parties and subject matter, and that you had a full and fair hearing, and the hearing was responsive to the issues that we raised, and nothing like that ever happens. You were in an administrative tribunal that doesn't have any judicial power at all. It's in the legislative and maybe even the executive department of government. Separation of powers, anyone, delegation of authority. And this is what the Supreme Court has now been ruling against in the last two terms and now into their third term for exactly this reason. So it's really great for us that this is coming up when it does. And this is what I used in my own case where, as you know, if you've watched my earlier videos, I got a summary default federal judgment, multi-millions of dollars. And I was sitting there ready to collect, and the next thing I know, I get a order, quote unquote, from the magistrate to whom I agreed that it was being dismissed on the basis it was specious, frivolous, and without merit. And here we are, the trial court, the attorney never shows up. And I put a 48-page unopposed motion in there challenging jurisdiction with added exhibits. And he has burden of proof there. Didn't even attempt to do it because he couldn't do it. If he attempted to do it, he convicts himself of treason on the record. So that said, I filed a case in federal court, what looks on page 1 like a civil rights action, but the other 35 pages say not so fast. What I'm really doing is a common law trespass via armis, and the bastard didn't show up there either. If we do that, we get a default in the first 30 days. See you later. We're going to take all your property. You had your chance. Should have happened here and didn't initially. So I get this notice, and I fire off a love letter to the presiding judge and ask in effect what the hell you people are doing here. And I explain Rooker-Feldman in great detail. You can't do this. If you're saying there's no judicial courts in the federal courts, and we have none in the state courts, what they're saying is that there are no states, there's no constitution, and all laws are null and void that are on the books, nunc pro tunc ab initio, from day one, as bills of attainder, taking of life, liberty, or property without judicial process. So that's what's going on here. And this is how we're going to get them, because I think the word is out now by the U.S. Supreme Court to the lower courts. They're getting the message here. Knock this stuff off. These people have rights out here. They're not artificial corporations like Chase Bank and IBM, and we have to deal with them effectively and in the way we're supposed to. So the sooner that happens, the quicker we get out from under. We get our government back, federated Republican government of defined and limited powers. And that's what we want, rather than this democracy, or as the Fifth Circuit recently described it, as an elective despotism. So it's just been a whole mess here. But we're getting close. And as I said in my last video, we had some good news from the U.S. Supreme Court in this area too, from my friend Adam, who's had some bizarre circumstances there. We don't know exactly what happened, but his emergency petition gets there, and it got there on a Thursday, and Friday was a holiday. So apparently they got the case officially, quote unquote, on Monday. Elena Kagan denies it on Tuesday, which she doesn't have the power to do with an emergency petition like this, especially since she's in the minority on the court now. We're playing to the conservatives, and we have 5 and probably 6 of those given the issues that we are raising. And this gets to them like it should. The case goes just the opposite way. So it came off the official docket on Wednesday, and my friend called me on Thursday, and it had reappeared on the official docket. And we don't know exactly why that happened. What I'm hoping is that Alito or Thomas or some of the conservatives were made aware of what happened with this petition, and they know their jobs and they know the law, and they got it back on there. Now, there won't be a hearing on the shadow docket. I'd love to have one, but they're going to make a ruling on it. It will be unopposed, and when that happens, we're right, they're wrong. What are they going to rule here? So we're waiting to hear about that too. You can visit this website, thespiritoflaw.com, and there'll be a lot of explanation about what's been going on with this case as well. And the good news is, a lot of these arise in what look like different factual circumstances. The DMV, the IRS, the F2B, the Securities and Exchange Commission, the Child Procurement Syndicate, but the legal issues are the same. Our unopposed constitutional rights are the same. We get rid of one of these bastards, we get rid of all of them. And that's what the U.S. Supreme Court is trying to do, mostly with the SEC right now. But you just put in the correct alphabet agency there, and you'd have a hard time distinguishing what they do from what you see in your courtrooms every time you go in there. And think about this quick note while you get there. Those of you who've been in their courts, you know damn well we walk in there, we're incompetent from day one. See you later. You want to try to appoint an attorney for you, which they don't have the power to do, by the way, even in a quote-unquote criminal case. In a criminal case, they try to enter a not guilty plea for you, which they also can't do. This is the Supreme Court again, those pesky 9 old farts saying it in both cases. And you get my documents, constitutional defense document package, you'll learn all about it. Send me an email, youwinincourt@gmail.com. So you've been through it, and you know that that's a huge, big deal, the issue of competence, and you'll learn all about that. But think about it. If we're not competent, among other things, how is it we magically seem to regain competence every 2 or 4 years on election day? How is it that the jurors, the members of the jury pool, are going to be competent to do jury duty? And they're never going to be told, unless our jury instructions get through, and they won't, but that's going to beat them, that they have the power to rule on the facts and the law. And they're damn well competent to do both. Now, another point of interest, not directly related, but think about this. How is it these days that kids in 2nd or 3rd grade are quote unquote competent to decide that they're a transgender entity. Give me a fucking break here. That has to stop. And that transgender business, that has its roots in civil rights, and that comes from the non-existent 14th War Amendment, which you'll learn from my materials. Send me an email, youwinnincourt@gmail.com. It's nothing more than another war act of the 39th Congress. That's why the yellow fringe is around the flags in all the courtrooms. That's a military standard, and they think that I, and everyone else is in the Army. That's what has to change, and Rooker-Feldman goes a long way to addressing that one, too. Wow, it's just a lot of good news coming, so much I almost can't keep track of it all, but I'm going to, and you can. Send me an email for my materials, youwinnincourt@gmail.com. You're going to love all of it. And that said, remember to subscribe, tell your friends, like the videos, get the word out. As soon as we cut out all this BS divide and conquer crap they've been using for 150 years and get out from under federal, regional, martial law rule, the quicker we get our rights back and our lives back and get them out of office and maybe into jail too, who knows. Thank you.